Advocate Hlachwayo.
Okay.
I don't know at what stage they were told to no longer be part of the case, but I know for a fact they are no longer part of the two cases.
All right. Maybe just correct my assumption or what I thought things meant. When you were setting out the 4 different streams that you have, each one of them led by a DDPP,
Yes.
I assumed that therefore there's only 4 DDPPs in IDEC. You now make a reference to Advocate Manilal.
That's correct.
As a DDPP.
Yes.
So does that mean you have more than just the 4, and where do they fit in these different streams that you have?
No. Commissioner Baloyi, at the time when the streams were set up, Advocate Manilal was still a senior state advocate. He was not yet a DDPP. And he was reporting to one of the DDPPs, Advocate Vetboy. And he only later became a DDPP. I think he went for interviews at some point for the position and was then appointed formally as a DDPP and became part of the DDPPs. And at that stage, then it would have been me and Advocate Manilal, Low, and Advocate Vetboy, even though Vetboy, her position was on contract, which ended last year in December 2025. And there was Advocate Annemari Friedman. So at some point we were 5 with the appointment of Advocate Manilal as a DDPP. We then became 5.
So when Advocate Manilal gets appointed, you say he gets promoted, he becomes a DDPP.
Yes.
When he gets appointed to replace you in these matters, DDPP law is again overlooked. He's also again not part of it. He's not the default.
He's like, yeah, that is correct. Even though the case
falls under his team, his stream.
Under his stream.
Okay. Thank you.
Thank you. On about 14 October 2025, I'm reading from paragraph 41, when the matter was due to proceed, the magistrate recused himself on the basis that he had been subpoenaed by the commission. I was of the view that the reason given was not legally sound, and after consulting the team and the investigating director, it's supposed to mean we, because I was not doing it for myself, but for the team, I launched an application to review the recusal. We consulted with the ID, we informed her about the recusal, and that the magistrate, the reasons that he gave were not in line with the established principle of recusal with reference to the decided cases, and therefore the unit then decided we shouldn't leave it lying. I must say, Commissioners, that it came as a surprise to both me and Advocate Mshololo, who were defending on the day, that before we started, the magistrate just said, I want to address the 2 of you. I've been subpoenaed by the commission, and as a result, he was recusing himself. He did not give us an opportunity to address him on what he was anticipating to do, and that's one of the reasons why we then took up his decision on review to say, in line with decided cases, at least you ought to have had us engage us, but in any event, the reasons that he was giving were falling short of the established principles, and that is why we took the matter up on review.
But that same consideration that he didn't give you the opportunity to address him when he decided to recuse himself, why was that not your consideration on the bail issue? Because in the bail issue, he didn't give the accused. We later learned in the appeal that the accused were not given the opportunity to address him on that condition.
Yes.
I'm not probing at this stage, it's because you've touched on it, but it is a subject of interest that I would like to hear you on, not necessarily now in full.
Yes.
but it's something that I would like to engage you on.
I understand that. Can I quickly just take out a copy of my book here just to make... yeah. Commissioner Baloyi, when the reason for that was, and we looked at the provisions of Section 60 of the Criminal Procedure Act. Especially at 60 subsection 12, if I'm not mistaken. I want to go there. Section 60, subsection 12, the court may make the release of an accused on bail subject to conditions which, in the court's opinion, are in the interest of justice. And Section 60 says the magistrate must weigh up the facts presented before him and the evidence before him. And at the time, even though neither of the parties had addressed him on this specific issue or condition, but our understanding was that he has the powers in terms of Section 60, subsection 12, to impose any conditions which, in his opinion, were in the interest of justice, allowing him to release the accused on bail. We objected to the appeal on those grounds, but when one reads the record of the matter at the High Court on appeal, and the presiding judge took me on that, and I had to concede, commissioners, that yes, much as I didn't know much about the case on the day of the bail application, I was seated there, but I remember that my fellow prosecutor, Advocate Manilal, was not engaged by the magistrate, neither were the defense, before the magistrate decided on this condition. And for that, that's the first point. But secondly, the magistrate did not give reasons for imposing this condition. And I think those two factors are what swayed the decision in favor of the defense, the High Court saying, when reasons are not given, it's difficult for a party to the proceedings to know why a decision was made against them. And there's a constitutional case to that effect. And furthermore, the fact that you are not engaged to address the court on that was also wrong, and that led to the conditions being set aside. On hindsight, yes, we ought not to have opposed it on those bases, but at the time, looking at the Act, it says there's nothing wrong that the magistrate did. He has the powers in terms of 6012 to impose any conditions. Had he given reasons, had he engaged us to address him, that condition would have stood.
Okay. We'll come back to it, Mr. Srunya, and because Ms. Johnson did testify to this, specific questions were asked of her about this, and she had certain answers and explanations. So I would like to hear your views about it, but we'll get to it.
Thanks, Commissioner.
Thanks, Ms. Paul.
Thank you.
Thank you.
Paragraph 42, the accused thereafter abandoned the Section 63 application. That is now, after the magistrate had recused himself, the chief magistrate was trying to arrange another magistrate to take over the 63 application. And the accused then, because of that delay, they then brought a Section 65 bail appeal. Section 65 of the Criminal Procedure Act bail appeal. We again had a discussed with our boss, and we're given a go-ahead to oppose the application. And both matters served before the High Court, and the judgments are attached as PS8. The judgment for the bail appeal and the order for the recusal is PS9. in the bail appeal, PS8, the High Court agreed that the presiding magistrate decision to impose the decision without engaging the parties and giving reasons was wrong in law and therefore ought to be set aside. On PS9, in relation to the recusal of the magistrate, the High Court ordered in our favor to say, yes, the magistrate ought not to have recused himself for those reasons given, not engaging you, and the reason given is also not in line with your rugby union matter. The bail appeal succeeded.
Serunye, just before you proceed with the next paragraph, in practical terms, you would have had a conversation about the bail amendment application, the 63. Did you have a similar consultation with the ID regarding now the bail appeal? And did she give positive permission or consent for you to proceed with opposing the appeal?
We did, Commissioners, and we informed the ID, and then she gave us permission to go ahead with the opposition on the Section 65.
And when you do that, does she have sight of any of the affidavits that are filed, particularly in opposition?